If the Texas Open Meetings Act was violated, or you suspected that it was violated, as alleged in the supplemental petition, why not bring criminal proceedings against the alleged violators?
I thought the civil proceeding was the more appropriate forum. I was not inclined to have anybody arrested for these violations. I thought the civil suit was a better arena to raise the issue.
But you do acknowledge that you, as the county attorney, are authorized to enforce the Open Meetings Act via criminal procedures, correct?
Objection form? You mean now or then?
At any time, as a general proposition.
As a general proposition, yes.
Is there a reason why you, as the county attorney, would not have been authorized to pursue criminal proceedings for a violation of TOMA in 2014?
No, I think I was authorized. I chose not to. So this appears to be a letter to the Board of Directors from the hospital's attorney, Kevin Reed.
Okay, and I want to call your attention to the second page, first paragraph, where it says, I have also been contacted by Andy Lucas, county attorney, who has expressed strong concerns about open meetings compliance by the district. Have I read that correctly?
Yes. And I believe I did have a discussion with Mr. Reed at some point. I believe he contacted me for some reason, and we had the discussion about the open meetings violations.
And what were the specific concerns about open meetings compliance?
That the board members were meeting and deliberating in private outside of the open meetings.
Anything else?
I think we just talked about how the board meetings were occurring, and I remember Mr. Reed explaining to me that there was an inexperienced board of directors and they were learning as they went. So my purpose in speaking to Mr. Reed about this was to try to prevent open meeting violations from occurring in the future. I thought it was important that the hospital district's council help advise the board in that regard.
Were the persons who you believed participated in the Open Meetings Act violations referenced here, did those include, or who did those include?
I didn't know who all it would include. I had seen the text messages from Mr. Harrison and Mr. Parker, but I didn't know that it wasn't occurring elsewhere. That was my reason for suggesting to Mr. Reed that he counsel the board.
You stated that the other parties to the text messages attached to the state's supplemental petition, which is Exhibit 6, were Mr. Harrison and Mr. Parker. Is that correct?
I believe so.
Did you or anyone else, to your knowledge, take any action against those two gentlemen insofar as alleged violations of the Texas Open Meetings Act?
No, really my thought at the time, and this really all occurred in a short period of time, my thought was that if the case were ultimately going to be tried to a jury, then depositions of those board members would need to take place. We never got to that point. I don't know that we ever would have.
Why not?
When we had the initial hearings, at that point I had heard the testimony, seen the evidence, and we had a ruling from the court. So I had more information on which to determine whether or not I thought it was a sufficient case to go to a jury trial, and I wasn't certain at the time that it was.
Why did you select to target Mr. Harper only for violations of TOMA?
Objection form.
The case was filed against Mr. Harper.